guardianship, and all the nuts and bolts that encompass or fall under the umbrella of guardianship. So without further ado, I'm going to defer. I'm going to pass the mic over to Susan Lacey. She's going to do a brief introduction, and then we'll go straight into the presentation.
Thank you, Sora Morella. Good evening, everyone, and thank you for being a part of our presentation this evening. I am honored to introduce you to Attorney at Law Antoinette Clark Forbes, known as Tony. Tony Forbes founded the Forbes Law Firm more than 25 years ago as a sole practitioner in the state of New Jersey. Her firm concentrates on estate planning, real estate law, guardianship, child custody, adoptions, and landlord-tenant matters. She is a trusted counselor, taking on tough, challenging legal matters as she diligently advocates for the most fair and just outcomes for her clients. Ms. Forbes' mission is to offer assistance to her clients with support that not only benefits their current legal needs, but guides them in forward thinking as they endeavor to make practical decisions for the future based on sound legal advice. Prior to entering the field of law, Ms. Forbes taught elementary school in New York City for several years. Her experience as a teacher has informed the manner in which she serves her clients' needs with honed problem-solving abilities, pointed listening skills, empathy, and a keen sense of ethical conduct. Ms. Forbes is a recipient of the Princeton Family YMCA Centennial Award for her community work as a mentor to an educational advocate for underrepresented students in various school districts throughout the state of New Jersey. She is also a champion of lifelong learning, which is evident in her volunteer work as a Girl Scout troop leader for 10 years, and currently as a facilitator and administrator of the YMCA Princeton Collaborative Girls Who Code Club, for which she is the head instructor of computer coding. So without further ado, I'd like to welcome and thank Tony Forbes for presenting to us this evening.
Well, thank you. Can you hear me? I hope you can hear me. Can you hear me okay?
Yes, we can hear you.
Yes. Thank you, Miss Lacey. Nice to see you. I'm going to just give a little spoiler. Miss Lacey was my daughter's principal at the school. And so lovely to see you.
Nice to see you too. Welcome.
Thank you guys for having me, and thank you, Morella, for inviting me. I'm just honored to try and share a little bit of knowledge about the law and maybe be able to just help some people if they have some concerns with guardianship. So we're just going to start right off with what is guardianship. So sometimes people become incapacitated. Adults may become incapacitated when they're older. Sometimes children are born with certain or have certain mental deficiencies or some sort of it could be a result of an accident of some sort. But in any event, guardianship covers a multitude of situations where a person is unable to take care of themselves. Okay, so they need the court to step in and appoint someone to do that. And most lovingly, it's a family member, and that's what we hope to be able to do. Sometimes it's not a family member. Sometimes the best person for the guardianship is not a family member. But so a guardian can be a person, or it also can be an agency. Sometimes an agency steps in when there isn't a family member or there isn't a person who is willing to step up and be the guardian for an incapacitated person or a minor child. And that guardian gets the legal authority to act on behalf of the ward, and that's the person who is incapacitated or the minor child. And they have pretty much total say in what happens to that incapacitated person or that minor child. However, the court always likes to hear when the guardian takes into consideration the ward's personal preference. Okay, so I just want to make a little distinction between a guardian and a conservator. When we have guardianship, there is a court adjudication um, telling someone or giving a judgment that someone has been deemed to be incapacitated. This is on the adult side. With guardianship, I'm sorry, with conservatorship, there's no adjudication of incapacity. However, a person may have property or assets that they're unable to take care of for some reason. It could be for a short period of time, it could be for a longer period of time, but with conservatorship, they're not in the conservator is not in charge necessarily of the person. The conservator is in charge of maybe assets or property that a person may have. And like I said, there's no adjudication that the person or the ward here would be incapacitated in any way. A lot of times we hear this regarding people in the entertainment business. All right, someone may, family member may think that the person is maybe not acting like they normally should or would, and they step in to just protect the property so that the person doesn't give away, all of their money, all of their assets, and then end up with nothing when they may be in just a state. Okay, but back to guardianship. So what would the court look at to say, yes, this person is in need of a guardian? So they look at things like, is the ward unable for some reason to just take care of themselves? Can they, and that's a large range there. So it could be from someone who is unable to physically take care of themselves, but maybe they have mental capacity, or someone who has who cannot physically take care of themselves, and um, they're not able to make decisions on their own. Okay. Um, but can they manage their own affairs? Can they do bank accounts? Can they do their own banking? Can they do all sorts of things that you and I do because we have agency? Do those people have agency? Do they have the ability to act in a manner that would allow them to take care of themselves? So if the answer to that is no, and someone makes an application for to become the guardian of that person, then the court will declare that that person is incapacitated and then also appoint a guardian. Um, Now, because of the creation of guardianship, when we have adults, they lose their individual right to make personal decisions about themselves. So the court is very, very careful to do this. And a lot of times we'll see older parents. People will want to have guardianship of their older parents simply because um, their parents may not be able to be self-sufficient anymore. Okay, and so, but the court wants to make sure that the person who is going to be the applicant for the guardian is qualified to do so. So there's not necessarily background checks on the person, but they do have to put in an application, and they do have to put in a verified complaint and attest to things like that they are doing it for the best interest of the person who is the ward. And what they do and what the court does then is does some investigation. So what I do as the attorney when the court indicates that it's time to do so, I will interview the would-be ward, or we call it an alleged incapacitated person. So I will speak on the phone. Now during COVID, we have to do these things remotely. But what I used to do is go in and meet them at their home. But now I'll speak on the phone with the incapacitated person, and that's closer to the court date that we get for a hearing. And I'll speak with the persons who are applying to be the guardian. And I'll just ask some questions and then just see where the person is, and what their desire is also, what their desire is. Now, there's also guardianship of minor children. So that comes about when sometimes I actually had guardianship of nieces and nephews. My husband and I did. My sister died, and then many years later, my brother died, and their I took their children. They had minor children, and one of the reasons for doing that, and not just having a family member come into your home, is because with guardianship, you get to put the ward or the person, in this case, minor children, on your insurance. Okay, you get to do all sorts of things that you would do for a child if it's a minor child. You get to do all the things that you would do for your own child for this minor child. And that becomes very important because the minor child, depending on why they are being why guardianship is necessary in their particular case, um, they may not have insurance. They may not have access to normal services that we need, or you may need to be able to get counseling for children, especially if it's a child that has lost parents. That is extremely important to be able to not only meet their physical needs and not only meet their medical needs, but sometimes psychological needs need to be met. And therefore, this is all expensive, and therefore it is necessary to be able to put the child on your insurance. Also, Miss Lacey will appreciate this. I could not just register my nephew and niece in school. I couldn't just go to school and say, hey, my nephew was living with me. By the time we were living in Montgomery Township, it was many years later, but my nephew came to live with us. And I couldn't just go to the high school and say, oh, Mr. Papadook, you know me. Here's my nephew. I had to have paperwork that said I was the guardian. I had to get what's called letters of guardianship to allow me to register a child in school. So guardianship is very important, especially I know that lots of people take in other family members, especially where I've seen it a lot is where a family may not adopt a child, but they may take a child of a teen that has had a baby. I've seen that a lot, and then I've also seen where they adopt the child outright. But a lot of times they'll take in a child for a teen, and with the hopes that one day that teen will be able to take care of that child. So there are a myriad of reasons why a minor child might be subject to guardianship, and but you want to have that. You want to have paperwork that allows you to take a child or register a child in any way, and then also put the child on your insurance. So there are basically three types of guardianship. There is guardianship of the person, guardianship of the estate, and then guardianship ad litem, and that has to do with minor children. So with guardianship of the estate, or guardianship, let's start with guardianship of the person. Guardianship of the person is the guardian has the ability to, it's almost like standing in place of that person. If that person were able to make decisions on their own, were able to take care of their own finances, were able to make sound decisions and care for themselves, that is what the guardian does. And the guardianship of the estate is a whole different type of guardianship. And they can be combined, but it's guardianship of the estate has to do with the property that a person has. So if we're talking about guardianship of an elderly person, They may have a business that they worked in. They may have buildings or real estate property. They may have stocks and bonds. They may have cash. They may have other valuable items. They may have just things that need to be taken care of. And maybe they can't pay the taxes on time because they can't drive anymore, so they can't get to the tax office, or maybe they're not computer savvy, and therefore they can't do it online. Someone may want to just be guardian of the estate of someone. And again, we see this usually with older parents and an adult child, where the adult child just wants to make sure that the parents' financial matters are taken care of. So even if I call the bank on behalf of a client, a bank won't talk to me. They won't talk to me at all. I would need something called a third-party authorization. Well, this guardianship letter, you would get a letter of guardianship that gives you that authorization to talk, to speak on behalf of, or to work on behalf of a person in the realm of their estate. Then you can have guardianship of the estate and person in one document. The court can give you both. Okay, but it's sometimes not necessary. Sometimes you just need, especially if a person is maybe just physically incapacitated, you may just need to take care of their physical person, and therefore, and they can take care of their other stuff. Maybe they have technology where they can take care of their own banking. They can take care of all of their other things. They just physically are not able to do so. So you can have a combination again of guardianship of the estate and guardianship of the person, or you can have guardianship of the estate and not guardianship of the person, or guardianship of the person and not guardianship of the estate. Another reason for splitting that decision sometimes as to whether you have both, you may have, and I see this with families a lot, there's always one family member, especially if there are a multitude of siblings, there's always one family member who's better with navigating the parents, right? Elderly parents. There's always one family member who may be able to get a parent to take medicine, to be able to do whatever they need to do. But that might not be the best person to manage the money. That might not be the best person to make sure that any of the assets that the parent has are being taken care of. So in that case, we may get one person appointed guardian of the person, and that person takes care of mom or dad. Excuse me. Or and then we have another sibling take care of the funds. Okay. And that can happen with minors too. You may have someone whose parents have left them a lot of money. They may, one of the questions that the court asks, especially if you have like a preteen or maybe a 10, 11, 12-year-old on up, the court will ask them where they want to live. The court will ask them if they would like to live with the person proposing to be their guardian. The court will ask them. And if they say yes, and there's a lot of money, but maybe that person is loving, maybe that person is caring, that person will make a great parent, but they may not know how to manage stocks and bonds. They may not know how to manage if the parent left that child assets like buildings or something. They may not know how to do that. And so what the court might do is appoint a financial guardian, separate from the person, or separate from the guardianship of the person in that case. Okay? Sometimes parents can't take care of their kids. Sometimes they just don't have the capacity. Sometimes it's due to drug use. Sometimes it's due to just an inability to do that, lack of parenting skills. Sometimes the parents may have their own mental issues that they need to care for. And that prevents them from taking care of their child. So in that case, a parent can go to the court and say, I need a guardian. I need someone to take care of my child. So it doesn't have to be that a minor is, an orphan without a parent. It could be that for some reason that parent just can't take care of the child, and in that case, the court will then award to a third person. And also, it doesn't have to be a family member. The court will award to a friend. The court will. What the court is looking for is a person who will um, act in the best interest of the child if it's a minor. Okay. And the same thing with adults. The court is looking for persons who will act in the best interest of that adult incapacitated person. So it doesn't have to be family members because there's not always a family member that's available or willing to take on the child. I took on 3 teenagers. Not a lot of my family members wanted to take on three teenagers. I had 2 at one time and then 1 at another time. And I'll tell you, it's tough because you're getting kids who were born in a different household, and then they have to learn to adopt to. They had to learn to adopt to our household, and it was tough. So not everybody can do that, and then often sometimes, like I said, the kids may not want to come to a particular household. Um, and the third type, so we have guardianship of the person, guardianship of the estate, and then the third type of guardianship also affects minor children. This is guardian ad litem, and that is where the court appoints someone where there's a legal matter that the child is either the subject of a legal matter, or a lot of times we see this in divorce. We'll see the court appoint an attorney that looks at the best interest of the child while the parents may be fighting and they may not be as attentive as they should be to the needs of the child. So what the court does is appoints a guardian ad litem, and that person looks out for the legal needs of the child. So what happens is, what we do is when we're applying for guardianship, the person will come to my office and we'll talk, or I'll talk on the phone now during COVID. And I usually create this, I have created a questionnaire. And I try to get as much pertinent information about the situation as I can. And from that questionnaire, I'm able to create what we call a verified complaint. And what that verified complaint is, it says to the court, court, please accept this application on my behalf. I would like to be the guardian of this particular person or estate, or person and estate, because I care about them. I'm concerned about their well-being, and I'm willing to do what the law requires me to do as the guardian to take care of that person. And so we put in a verified complaint, and what goes along with that is something called a certification of assets. So again, we go to look at what kind of income does that person have. Okay, maybe they're getting Social Security, maybe they have a trust fund, maybe they have some sort of pension, maybe they are getting any other kind of source of income. Maybe they have a huge bank account, maybe they have no bank account. The court would like to know exactly what kinds of assets a person has, because that goes into the determination as to, is this person fit to be the guardian of the person, or the estate only, or the person only, or both. Okay, so a combination looking at what kind of assets the person has, we put in what's called the certification of assets, and that's a factor that the court looks at when someone is making an application. If the court ever thinks that somebody is making such an application because they want to have access to the funds that a ward may have, of course, that application will be denied. Okay? And then we also have to have um, the certification of at least two doctors. One can be a psychologist and one can be a physician. And that is because the court is just not going to take my word for it that somebody is incapacitated. The court is not going to take the person who's making the application's word for it that someone is incapacitated. Again, there are all sorts of nefarious reasons sometimes that people want access to what other people have maybe earned in their life. And so the court wants to make sure that any such application is done with the utmost honesty and the utmost, and that it's real. So therefore, the court is going to require that a physician do an examination, and it doesn't have, it's not extensive, but they'll do an examination and then say, yes, this person is incapacitated. Yes, this person cannot take care of themselves. And therefore, in my professional view, as a physician, I am supportive of this application by the guardian to be the guardian of this person, because I can say from a medical standpoint, this person is not able to take care of themselves. And then the same thing from a psychologist or a psychiatrist. The court likes to see that there's some sort of evaluation from such a professional to make sure that the person is really incapacitated and unable to take care of some and make decisions on their own. So, like I said, some of the duties of the guardian is to make sure that the person is seen by a doctor, regular doctor, and this is outside of the application, but to make sure that the person gets health care, to make sure that the person maybe they like going to the movies. So the guardian is supposed to make sure that the needs and the preferences of the ward are met, and not just okay, I'm guardian, I just you just sit home and don't do anything. You really have to try to engage the incapacitated person and try to meet some of their needs and make sure that their preferences, things they like to do, are met. And if the elderly person likes to play bingo 7 times a week, then to the best of your ability as the guardian, you should try to accommodate that. To make sure that the person is engaged in social activities with their friends. Maybe they just want to be able to, see their friends in non-COVID times. The guardian has the obligation to do that. And then also the guardian has to make sure that that the mental health of the person is being addressed if that is an issue. They have to make sure of that because the court wants to make sure that the whole person is being taken care of. Okay? What you can't do as a guardian is you can't entrust your duties to somebody else. So I've seen this with family members where one person in the family maybe looks best on paper. And so the family puts that person up to be the guardian. But that person has no interest in being the guardian. And what they do is they pass all the duties off to another person in the family. They're not supposed to do that. The ward does not have to live with the guardian, but the guardian has to be in charge and taking care of that person. And so they can't just abandon the ward with somebody and then never see the ward again. And they're supposed to be the person that's engaged in all the necessary and pertinent activities of the ward. But you can't pass it off. You cannot pass it off to somebody else. You really have to act on behalf um, of the ward. At some point after the court proceeding and after a person is appointed as guardian, they will get what are called letters of guardianship. And those letters of guardianship allow the guardian to go to a bank per se and say, hey, I can take charge of this person's bank account. Or to go to a doctor and say, hey, you can tell me what's going on with this person because I have letters of guardianship, which means that I am responsible for what happens to him or her. Okay, so it's much like letters testamentary, if you will, for estate matters. When someone passes away and someone becomes the executor of someone's estate, they get what's called letters testamentary. But this is letters of guardianship, and that allows you to do everything that ward would be able to do on their own if they had the capacity to do so. And so those are very, very important because, again, I had to show that. I had to show that I had a letter of guardianship for each of my nieces and my niece and my two nephews that came to live with us. Okay? And no one has to respond to you saying that you are in charge of another person if you can't prove it with a court order. And basically, a court order or judgment, in this case, the court judgment, appointing a person as the guardian opens a door. Whereas, I don't know if you guys have ever tried to help somebody else. You call a bank or you call a doctor, and the person says, well, we can't talk to you. Okay, we can't talk to you at all. Well, the letters of guardianship opens that door for you. Okay? So after you have that, it is important that you keep excellent records, especially if there are assets that the ward has. So there are reporting requirements. Now, depending on what the judgment from the court says, that it's usually annual. It's usually annually the court says, we want to know how the ward is doing, and we want to know how their finances are going. So there's a reporting requirement that the guardian must submit to the court. And if it's a really tense situation, the court may require the reporting to be more frequent than annually. Okay? Now, there's also an accounting that has to be done, and that goes to the money that the ward has. So it could be income, it could be their assets, it could be any kind of income or money or assets that the ward has. The court wants to make sure that you are taking care of it. So like if it's an elderly parent or a child whose parents leaves him or her something in the way of an asset, let's say a real estate, a building, you as the ward or you as the guardian have to make sure that that asset is being taken care of. So if there are tenants in a building and that they pay rent, you have to make sure that they're paying rent. You have to make sure that they are that money that should be going to the ward gets to the ward, and it could be put in a trust account or so. But you have to make sure that person's assets are being taken care of. And the court, it's not that you just say, yes, court, I did it. You've got to submit a report. You have to submit an accounting and a report. And that's also why a lot of times they'll split the duties of one person being um, the guardian of the person and another person maybe in a family being guardian of the estate, because depending on the size of the assets, it can be tremendous, tremendous, I wouldn't say burden, but responsibility. Um, with minor children, the guardianship ends when that minor child becomes emancipated. So, emancipation in New Jersey, um, there's a presumption that at 18 the person is emancipated and becomes an adult, but that's just really a presumption, because a lot of times kids will go off to college and they're not really emancipated. They can make their own decisions, but they're still under what we call within the sphere of influence of their parent. And so once the child is emancipated, then the child no longer is, the guardianship is extinguished, we'll say. For older parents, if that the guardianship will last until the person passes away. I have a case right now where the guardian was the parents, and they have the ward is a 60-year-old incapacitated person. He's physically incapacitated and also mentally incapacitated. The parents are now 93 and 87. They cannot take care of this 60-year-old incapacitated, physically and mentally incapacitated person. He is in a facility, but the brother has stepped in to say, hey, I will take over being guardian of my brother, even though my parents have guardianship. The parents' guardianship would continue. As long as everybody's alive, it continues. But here, they're not able. They can't, the father and the mother can't drive anymore. They have their own physical illnesses, so they are not able to be the guardian any longer. So the brother, who's 56, we are doing a substitution of guardianship, because ordinarily, unless there's some sort of really bad thing that happens and there's a termination of the guardianship continues as long as everybody is alive. And let's see. I think that's about it. We'll do this. There's a substitution that can be court fees. It costs $200 in New Jersey to do the complaint, and then to get the papers that go along with the guardianship, the letters of guardianship. That's a $50 charge, and so it's basically $250 to do an application for guardianship, and that's whether for a minor or for an incapacitated adult. And then if you want copies, it's kind of $5 a page after that. It's not terribly expensive. So that's guardianship in a nutshell. And I'd love to take any questions if you have them, but I hope it's been at least helpful in giving you a broad overview of guardianship. And every single case is different. Every case is different. So there are minor adjustments as we go along.
So, well, thank you, Attorney Forbes. Thank you so much. I'm quite sure you gave us a lot to think about that we've never had to think about in terms of guardianship of estate, guardianship of person, guardianship of minor. So I do have a couple of questions in the chat.
Okay.
The first one is, do you need to obtain an attorney to draft a legal guardianship document?
You don't have to. Anything that you want, anything an attorney can do for you, you can do on yourself. Just like you can do for yourself. Just like you can represent your own self in a criminal case, you can do this. However, it's complicated. It's not just filing a piece of paper. And the court expects when you get to court that you've done all the things that are necessary. So you don't get a pass for not being an attorney when you get to court. You have to have all the pieces together, and you have to be able to follow along. So it's not necessary. I would not say that. I encourage it, of course, but it may be, depending on how complicated your situation is, it may be in your best interest to do so, to have it.
So the next question, if the capacitated person is in a nursing home, what are some things the guardian should monitor? And what are some things that the guardian should put in place in the event he or she passes first?
So there, you cannot pass on your guardianship. So what you might want to do, if a person is a guardian and they are experiencing maybe some terminal illness, then they may want to move forward and have a substitution put in before anything happens, so that they would not be, so that the guardian, the ward is not without a guardian. Okay. One of the things that you want to monitor is just to make sure that the person in a nursing home is being taken care of properly. You want to visit and make sure that they are getting all the medical needs that they are, and also all the maybe stimulation, or maybe that I've been in nursing homes where people are literally placed in the hallway for 4 or 5 hours a day, and they're in their wheelchairs, and they all just kind of just sit there for a long time. Occasionally there'll be a movie, occasionally there'll be some sort of interaction, but you have to pay attention if you have a a family member or someone in a nursing home. So what you want to monitor to make sure that they are being engaged, especially if they're just physically incapacitated, but maybe mentally they're still, they're aware of what's going on, and there should be some stimulation. So you have to monitor even if somebody's in a nursing home.
Okay. What could you tell us the difference between power of attorney and guardianship?
Okay. A power of attorney is a document created um, by lawyers or by yourselves. You can do that also, which the person, and we call that person the principal, makes a decision that I want someone else to handle certain aspects of my life. And what you can have different kinds of power of attorney. So you can have someone that you want to just handle all your medical issues. Okay, talk to the doctor on your behalf. Make decisions when you are where you will be treated, what doctor will treat you. Make decisions on perhaps what kind of treatment you may have. You can have somebody who just does medical, who you can appoint as your medical power of attorney agent. You can have someone appointed as your agent to just maybe handle your business, handle your business things, your banking things, other things. You're fully capacitated in your mind, but maybe if those of us who have elderly parents, we know we have to do certain things for them. And again, I can't just walk into the bank and say I need to do something on behalf of my mother because she's my mother, right? I need some sort of paper, some sort of document that says that. So the power of attorney comes directly from the principal, which is the person giving the power to someone else to act and stand in their behalf. Okay. Sometimes I do power of attorney when I have a husband and wife, and maybe one is traveling when they're doing a closing, a real estate closing. And the wife is, let's say she's traveling because her job determines that she has to travel and she can't be at the closing. So what happens is she gives her husband power of attorney, and he acts in that very narrow capacity to sign papers on her behalf. You can have power of attorney documents that are very broad, and you can make them very, very narrow, so that only in this case does this person act on my behalf. The other thing is power of attorney dies when the person dies. Okay, so there's no after a person has passed away, there's no power in the power. So the power of attorney stems from the person themselves, whom we call the principal. The guardianship is an appointment from the court that says that someone else can act on behalf of another person. So that's one of the primary differences is that a power of attorney is generated or birthed from the principal and him or herself. The power of the guardianship comes by via an appointment by the court.
Okay, the next question, are there some things that we should put in place now in the event that we become incapacitated?
Yeah, so I do estate planning, and one of the things I do is I do a package of things that people can select from, and there's a sort of like a menu. One of the very important things is an advance directive. An advance directive says to any doctor in the future, any of your family members, here's what I want to be my medical treatment in the event that I become incapacitated. Again, it can be very broad or it can be quite narrow. Some people don't want to be resuscitated. If they have a heart attack, they say, let me go, right? Some people want every single kind of resuscitation. They want feeding tubes. They want do everything in your power to keep me alive, okay? An advance directive would give you the say when you can't really say for yourselves anymore. And they are honored by the hospital and doctors, and they are honored by the court, more importantly. I do a power of attorney. And there's, like I said, two types. You can have a medical power of attorney. You can have a regular durable power of attorney. That I would put in place. Put in place a will. Do a last will and testament. You may think, I don't have a lot, of assets. I don't have a whole bunch of buildings. But maybe you have some special jewelry that was passed down to you from your grandma, right? And you want to pass it on to a particular niece, or maybe you have some family heirloom, or even just some things that you have that somebody else might like, and a grandchild or a granddaughter that says, "Oh, I love those dishes. I love that china," and you want to make sure that that person gets it. You do that with the will. Okay? So you don't have to have an extensive amount of assets to do a will. I encourage people to do them anyway. And I encourage people to include every child that you have in the will. A lot of times parents will do, if the most successful child, they'll leave out of the will because they think that that person can take care of themselves. So leave something for everybody.
Okay, another question, are there situations where a parent retains some rights when there is guardianship?
Yes. So even if you have if someone else has guardianship of your child, unless that person has guardianship of the estate of your child, you're still financially responsible. Okay. The guardian has to make sure that the child eats. The guardian has to make sure the child has clothing. The guardian has to make sure that the child has all the things that the child needs. But your financial obligation as a parent does not cease when someone else has a guardianship of your child.
About how much would it cost to do a will?
It depends. That depends on the assets that a person has. So the more assets, the more complicated the will is. Then of course the more it costs. But that really is very specific to what a person has in the way of assets, and also what they want to do. Okay, so if they have young children and they want to create to make sure that certain other persons take care of their children if something happens to them, you can do that in a will. You can make a testamentary guardianship, and um, so those that's what it depends on. It depends on exactly what you want to do. Again, I do a questionnaire, and that gives me a sense of what the person wants, and then we go from there.
The next one, does the guardian claim the person on their taxes?
It depends on the full breadth of the guardianship. If you are fully taking care of the ward, and um, part of your income, of course, goes to take care of the ward, you can there are you can claim that person as a dependent. But I am not an accountant, so that's the extent of what I'm going to say about that. And I suggest you have to see your local accountant.
Fair enough, fair enough.
I know stuff, but I can't advise it.
What is the time frame for applying for guardianship, and when do you suggest that a person should start?
Okay. The time frame, these days I can't really give you a good time frame for anything that goes through the court. Simply because while the courts are open and the courts are doing business, things are not moving as fast as they ordinarily would. So, um, from what I hear from the clerks that are there, you used to be able to walk into a court and you'd see 30 people in the clerk's area. Now you may see 5. And so they may come in every other day. So somebody, or once a week, or maybe every other week. And so the paperwork is not getting as done as fast as it ordinarily would. Okay? So I can't give you a time frame. If you have someone who you think is moving in the direction of being incapacitated, um, I would talk to their physicians, and see if that is something also that they would want you to do. Because, like I said, the court does like to know that the preference of the ward is being also adhered to.
And when is a good time to apply? I think you answered that, to talk to the doctor. More so for our young people that are turning 21. Should they start? How soon should a parent apply for guardianship for our children?
I would start as soon as you can, because you want to be in place in case something happens. You want to be able to step in with authority of the court, and that little guardianship letters of guardianship gives you that authority. So if you are aware that someone's turning a certain age really soon, and you're going to want to be their guardian, I would start as soon as possible.
I don't see any more questions in the chat. I would just ask everyone to look in the chat if they could complete the evaluation form for us, so we can continue to do these types of workshops for the community. And I would just, if there are no other questions, I'll put the link for the evaluation in the chat again. So any other questions before we say good night to Attorney Forbes? No more questions?
Okay.
Well, I would just, first of all, on behalf of the scholarship committee, of Delta Sigma Theta Sorority Incorporated, Trenton Alumni Chapter. Thank you, Ms. Forbes. Thank you for sharing this valuable information. So many of our so many people in our community just don't know until we're faced with the situation where we have to either get a power of attorney or guardianship. And it's nice to be proactive instead of reactive, particularly when it comes to matters of our loved ones. So thank you so much.
I did see someone look for my
yes,
contact information. So I'm
put
going
that
to
in the
put,
chat for me.
yeah,
Thank
I'll put
you.
it in the chat for
Thank you, thank you, thank you.
Let's see. Oops, I'm sorry. I pressed return too quickly. Okay. So I put my email and my phone number. Okay. And happy to have an offline consultation with anyone and, maybe address some of the issues that are particular to you. So thank you again for having me. I appreciate it. And I'm always glad to be engaged in this way. And Miss Lacey, so lovely to see you. And I'm just going to tell you guys one thing about Miss Lacey. She was so gracious a couple of summers ago, 2 summers ago. I ran a physics, robotics, and it was physics, robotics, and coding little mini camp. And Miss Lacey was gracious enough to let us be in one of her classrooms. And I was always appreciative of that. And
Well, I can't say enough about you because as you see, she's a very skilled attorney and she's an awesome mother and community member, and she gives back to our school district community quite a bit in so many ways. So thank you so much. It's good to see you and tell your family hello.
Thank you. Will do. Will do.
Thanks for doing this for us.
You're welcome. You're welcome. Okay.
Before we get off, I just want to give an opportunity to the president of the chapter, Nicole Carmichael. She's on the Zoom call, as well as the chairperson for the scholarship committee. If they would like to say anything, I definitely want to acknowledge their presence here on the Zoom call. If they wanted to have just some words before we close out, I will give them this opportunity now.
Sure. Thank you, for Holmes. I would like to thank all of you who participated, who attended tonight. I see we have quite a number of people here on this session, and it's also been shared to Facebook. So people will be able to go back and look at it. I received a lot of information because I didn't think about it the way that you, spoke and you actually broke down the A's and C's to it. Many times we think about, when children are born, oh, well, these are the godmothers and the godfathers, and that's it, but not really thinking about everything else that it entails. So I truly appreciate all the information that you've shared with us tonight. I'm sure that our audience will go back and look at it again, and just thank you. And I'm sure we'll be working with you again in the future. Thank you.
Oh, wonderful. Thank you. Thank you.
Good evening, everyone. This is Sharon Davis. I'm the chairperson of the Scholarship Committee. I'd like to thank all of you for attending this session, and I especially like to thank our speaker. I am a guardian, and the information that you gave me, I really wish that I had had that before before it happened.
Yeah.
And I would like to just encourage all of us to really remember the information that you've given us today and to do some pre-planning, especially not only in the event that this might happen with you, but also, with you becoming a guardian, but just also because it could be us one day. So we should make, the necessary arrangements and all ahead of time. Mm-hmm. So just thank you all. I appreciate you being on, and good night.
Okay.
Make sure you fill out the evaluation form, everyone. And thank you so much for your support. This is what we do. We're here to be those bridges. In fact, that's what the program is for this grant that we received, Building Bridges to the Future. So have a good night, everyone. Take
Good
care.
night. Thank
Sorora
you.
Morella,
Oh,
Sorora
yes.
Morella,
Yes, ma'am.
I'm
Yes, ma'am.
sorry.